Welcome to Risk, Liability and Litigation with Kevin Mayer.
Welcome to Risk, Liability and Litigation with Kevin C. Mayer, partner at Logan Mayer, LLP in California. Kevin is a seasoned trial attorney who helps businesses navigate complex legal disputes, regulatory challenges, and high-stakes litigation when the risks are significant and the outcome matters. I'm Lisa Mosbey, and today we're talking about OSHA citations, how they happen, and what businesses should know when deciding how to respond. Kevin, welcome back. Thank you so much for joining me.
It's so good to see you again, Lisa. Thank you.
Yeah. Kevin, what usually leads OSHA to issue a citation after an investigation?
Well, first of course, there has to be an incident. Something has to occur that is a reportable incident. And that can be reported either by management of a company or by an employee if they perceive there to be a potential violation of the relevant occupational safety and health regulations. So let's assume an incident occurs, and I'll just pick an easy example. During a refinery turnaround, independent contractors are on the site, they're shutting down units, they're de-electrifying units, they're doing whatever they need to do to repair equipment to put it back into service to produce petroleum products. And let's assume that there is an explosion at the cat cracker unit and people are killed or severely injured and equipment is destroyed as a consequence of that explosion. So OSHA will receive notification virtually immediately from the company about the incident, and they will show up in a situation like that, typically with multiple investigators from their high hazard unit in order to commence an investigation. So citations are issued when, as a result of that investigation, OSHA determines that there have in fact been one or more violations of relevant sections of health and safety regulations. That could be the health and safety code, it could be the labor code, it could be the business and professions code, but they are typically going to cite the regulation, provide a factual summary of what they found and what they concluded in order to justify the issuance of the citation. And then the citation will be classified. In a situation concerning the incident that I described, where you're dealing with fatalities and serious injuries, it's virtually certain that most of the citations issued will be classified as serious. What you're hoping not to get is what we call a willful and serious violation, where OSHA would have determined that it was because of either deliberate misconduct or deliberate misfeasance by the company which led to the violation in the first place. Other citations may also be issued which are either classified as administrative, which is typically a record-keeping violation, or general for less severe violations that they have found. Once those citations are issued, the company now has a limited period of time to decide how it's going to approach it, whether they're going to appeal those citations, either because they believe they didn't violate the regulation that was cited, or they believe the classification is in error, or they believe that the proposed monetary penalty is too high under the circumstances, or, and we find this quite frequently, OSHA issues multiple citations for really what amounts to one violation. And they're doing that because they want leverage in settlement negotiations with the employer in order to stick them with at least one or two citations while they agree to dismiss one or two others in exchange. So I'll stop there.
I'm following you 100%, Kevin. Have you worked with cases where a citation initially seemed minor but ended up creating a much bigger problem for the business?
Absolutely.
Yeah.
Something could happen that you consider to be sort of a one-off situation. And while there might have been a serious consequence associated with that, another example I could give you is in a munitions manufacturing plant, a government contractor that worked for our federal government. And in this instance, they were producing the mechanisms that actually blow the canopies off of military aircraft when pilots have to eject, either because they've been shot or because there's been a mechanical failure in their plane and they need to get out. So these munitions actually blow the canopies off so the pilots can safely eject. Well, one of their longtime employees actually mishandled those materials in violation of the training that she actually gave to other employees. And among other things, she was wearing the wrong clothing and produced an electric spark, which set off a whole tray of these things. So they all exploded really in her face. Fortunately, she survived, and it was clearly a one-off situation. It never happened before. It never happened since, but they still have to be reported because it was a serious injury that resulted. Well, OSHA came in there, and of course, as we talked about in the last episode, they also can't ignore other potential violations of health and safety regulations that they observe while they're there doing their investigation of the incident. And in this particular circumstance I'm thinking of, they also cited the company for a number of record-keeping violations, as well as some other health and safety violations that they thought rose to the level of a serious violation. And so we found ourselves dealing with not only the investigation and the citations arising out of the incident, the explosion of these munitions, but other incidental findings, collateral findings that were made by OSHA while they were doing their investigation.
Wow. We need to be paying attention because that's how you get caught doing something you shouldn't be. Kevin, once a company receives an OSHA citation, how quickly does leadership need to start making decisions about the next steps?
Well, leadership should typically be engaged right at the get-go. As soon as there is an incident, and indeed even beforehand, leadership should always be thinking about their OSHA compliance program. And of course, once an incident actually arises, they should be doing an internal investigation themselves, separate and apart from the OSHA investigation that is ongoing. And that internal investigation would typically be conducted with the aid either of in-house attorneys or outside counsel who understand and specialize in doing OSHA-related work so that the attorney-client privilege and the attorney work product doctrine can protect that investigation to the extent the company wants to keep things confidential so that they can engage in remedial measures that don't necessarily have to be disclosed to OSHA under the circumstances. But once citations are issued, now the company has to make a decision. Do they recognize those citations, pay the fine that has been issued, and simply, as we like to say, eat it? Or do they want to appeal it and contest it? And typically, when one is appealing it, you appeal it on all available grounds. So you contest the citation itself by saying, no, we did not violate the regulation that you have cited us for. B, the classification is too high under the circumstances. C, the proposed penalty that you want to issue is too high because you want more dollars from us than we think you're entitled to under the circumstances. Or D, and this is one we talked about a little bit earlier, you have cited us for multiple violations where only one would have been necessary under the circumstances because it really is the same thing. And you're just trying to repackage it in 3 or 4 or 5 different ways. So all of those grounds are available to appeal.
And then what are the options when a company disagrees for the company to challenge a citation?
So sometimes we have what we call employee misconduct. In other words, the company has been cited for violating a regulation, but the reason that they were is because an employee or a group of employees who were involved had actually violated their training. They actually did not follow what they were supposed to be doing. And the company can demonstrate that they had adequate training to the employees, that they had a program in place for enforcing compliance with OSHA regulations, and that the employees themselves could face discipline as a consequence of violating that. There's a whole series of criteria that an employer has to show in order to demonstrate that employee misconduct amounts to a complete defense against the citation that has been issued. So that's always a good ground that can be pursued. Another way is to contest the allegations of employer misconduct. Sometimes you will get a very aggressive OSHA investigator, and for whatever reason, they're looking for pelts on the wall. They're looking for citing them for whatever they can, for as high as they can, and for as much as they can. Why they do this, I don't understand, but they do. And so sometimes you can demonstrate that an overly zealous OSHA investigator has been completely biased in the way that they approach this investigation, haven't looked at all the evidence, or at least have looked at the evidence and ignored critical evidence in order to arrive at their conclusion. So those are ways of attacking the citation itself in order to demonstrate that you as the employer did not actually violate the regulation at all under the circumstances. As with any affirmative defense, the company has the burden of proof on this issue. So the OSHA investigators, when there is an appeal of a citation, have the burden of demonstrating, as any plaintiff would in civil litigation, that a violation of the regulation actually occurred. That's their burden. But then if you as the employer want to pursue one or more affirmative defenses to the violation, the employer has the burden of proof on that. They do not have a burden of disproving the OSHA regulation. They merely can argue that OSHA hasn't sustained its burden. But that is a determination that, if it goes all the way, is left to the discretion of an administrative law judge. In OSHA matters, you're not trying these cases to a jury. You're trying them to a single administrative law judge. And obviously, neither side would prefer that as a remedy. They would much rather resolve these things through settlement negotiations, often after discovery has occurred. So in a lot of instances, when I've appealed citations, I have obtained the complete OSHA investigation file as well as our company's investigation file, and I've actually deposed the OSHA investigators in order to demonstrate the flaws and the faulty thinking that led to the investigation citations. And as a result of that, then we have the ammunition that we need to successfully resolve the cases short of going to an administrative law trial.
So, Kevin, what should companies understand before deciding whether to challenge an OSHA citation?
Well, you have to think about what the consequences are if you let the citations go through. Like anything else, if a company builds up a reputation as being a frequent violator of OSHA regulations, these things start to add up. And so if a company gets hit with repeated serious violations, or they get hit with willful and serious violations where OSHA finds that there is either intentional misconduct or what amounts to reckless misfeasance, failure to act when they should have, that can be a problem. It starts adding up. The fines get much heavier. And indeed, if you are considered a repeat offender, that is, you have been cited before for a violation of a regulation, and then another incident occurs and you get cited again for the same violation of the same regulation, that can have very heavy consequences and may even influence the ability of your company to operate or to continue to operate in that facility.
Interesting. So there's only a second chance. Yeah, there's not more than two chances. You need to
Well, there
correct
can
it.
be second and third chances, but you never want to get to that point, Lisa.
Mhm.
You're playing with fire at that point, and the old expression is you can't fight City Hall. Here, when you're trying to fight OSHA, but you have a record of continuous violations, and indeed, if they are repeat violations, you're really barking up the wrong tree. That's a very dangerous place to be as an employer.
It's a powerful organization and they're there for a reason. Kevin, how can an OSHA citation create a bigger legal and operational problem for a business long after the investigation ends?
Well, you may remember, Lisa, we talked about during our first episode when we discussed OSHA matters that there can be collateral matters that go along with the OSHA investigation. So, for example, the criminal prosecutors, either the city attorneys, the county district attorneys, the state attorney general's office, could get involved in something if they perceive there to be criminal conduct which may be worthy of investigation, indictment, and prosecution. There can also be civil liability and exposure that arises out of any incident. Typically in most states, we have what is called workers' compensation exclusivity. This is a public policy matter in order to prevent employees from suing their employers for damages and injuries that they may suffer in the course and scope of their employment. We do this because we want to have a predictable system of resolving those claims between employer and employee. However, there are exceptions to that, particularly when employer misconduct is involved. And it also does not insulate the employer from lawsuits by the injured family members, and in some instances, by what we call NGOs, non-governmental organizations that exist to promote the public interest. This typically arises in environmental contamination circumstances. As an example, we had an incident several years ago where a winery here in California had a spill out of a storage tank. And as a consequence of that, we were dealing with 5 separate incidents. We were dealing with an OSHA investigation, a situation with the district attorney's office that was looking at potential criminal exposure, civil exposure by plaintiff's bar, environmental health and safety NGOs who were looking for their civil penalties that they could enforce, and then finally potential civil liability arising from people who claim their property was damaged as a result. So there can always be these collateral matters that arise out of any major incident which could expose the company to much greater liability.
Right. Thank you so much for the information. It's been eye-opening once again. I appreciate you walking us through these different matters pertaining to citations.
It's been a real pleasure, Lisa, as always, and I would caution every employer who is subject to OSHA regulations, which is the vast majority of them, that you have to take these obligations very seriously and don't wait for an incident to occur before you start looking at your compliance responsibilities.
Well said. Thank you so much for joining us for this episode of Risk, Liability, and Litigation with Kevin C. Mayer. If your business is facing complex litigation, regulatory investigations, or other high-stakes legal challenges, you can learn more at loganmayerllp.com. Be sure to like, subscribe to the show, and leave us a review. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.